Hello, everyone. Welcome back to the third and final panel on the Energy Charter Treaty and the EU law perspective. So it's the third panel on withdrawal, modernization, modification, the way forward. So we look ahead, and we look ahead with three speakers on this panel. That's Blerina Xheraj, who speaks on paradoxes of the ECT modernization process, new challenges and old clues. On my far right, sitting right next to me, is the second speaker, Vid Prislan, who speaks on investment protection post-ECT and the question of whether customary international law is a problem. And on the screen behind us, or in front of you, there's Kyla Tienhaara, zooming in from Canada, I believe, who speaks on the protection of fossil fuel investments under the modernized ECT. The speakers, as always, today have 15 minutes. I keep them to the time, and we open up for general discussion. So I'm looking forward to your contributions on the panel and in the room. Blerina, the floor is yours. Sorry.
Thank you very much for the kind introduction and good afternoon. Before I start my presentation, thank you. I would like to thank the organizers of this event for inviting me to speak today. It's a pleasure to be here at the Amsterdam Center for European Law and Governance. It's also my first time at your building. It's also a pleasure to join a distinguished lineup of speakers. In my presentation titled Paradoxes of the ECT Modernization Process, New Challenges, Old Clues, I will address public international law principles and the role that they play in shaping the ECT modernization process. I will not be using slides for this presentation. But before I delve into those purely legal issues of public international law, I think that it's important to make some preliminary remarks on the context surrounding the modernization process of the Energy Charter Treaty. The first observation focuses on the general climate surrounding the process. This process is maturing under a challenging geopolitical context. Following Italy's withdrawal from the ECT in 2016, many other EU member states have declared their intention to abandon the treaty, and that includes Poland, Spain, Netherlands, France, Germany, Belgium, and Slovenia. For these countries, the modernization process does not sufficiently preserve the integrity and primacy of the EU legal system. This is the position of Spain in the letter addressed to the European Union Commission. The process does not change the ISDS clause and does not eliminate threats to the autonomy of the EU law and the principle of mutual trust between EU member states. This is stated in the Poland draft law on the termination of the Energy Charter Treaty. The process does not reflect, international climate commitments and CO2 emission reductions, which is the position of France. And again, we've seen that on 21st October in the statement. It's also said that it does not comply with the EU climate objectives expressly stated by the government of Belgium. And it does not sufficiently align with the Paris Agreement and does not serve its initial purpose anymore. This is what Slovenia stated in its intention to withdraw from the ECT. For these reasons, Spain, for example, has already communicated to the European Union Commission that for coherence, it will not support the modernized agreements. It's undeniable thus that the withdrawal from the ECT of these EU member states is expected to have a huge impact on the regional and international energy governance. But as EU member states are planning to leave, the ECT is continuing to invest in its outreach strategy that the Energy Charter Secretariat started in 2012, the so-called CONEXO policy. The ECT is actively recruiting states from the global south, especially Africa and Asia, including Iran and Pakistan. Many African states are now at various stages of the process of joining the ECT. Nigeria, for example, has already completed the first 3 steps of accession to the Energy Charter Treaty, although the process has been put on hold for the moment, pending the outcome of the modernization process. For these countries, there are apparently good reasons, valid reasons, to become members. The second remark, contextual remark, is one that concerns the nature of interests and policy objectives underlying this process. They are competing and conflicting interests. On one hand, the need to promote and protect investment in the energy sector in a traditional way, including procedural and substantive protection, and on the other hand, the need to achieve ambitious sustainable development and climate change goals. The success of the modernization process is thus measured by the ability to deliver on those contradictory policy objectives. And the third preliminary reflection relates to the existence of dualities of approaches in this process. So what I mean by that? I think that there has never been a unitary approach to the modernization process among ECT contracting parties. There were different reform timelines on the table when the reform started, which may have contributed to this duality of approaches. And the modernization mandates proposed by the 2 main blocs, the Energy Charter Conference and the EU, were different too. The Energy Charter Conference officially launched the modernization process by adopting a decision in 2017, but by November 2018, it had already determined a closed list of topics for the modernization of the ECT. The Council of the EU adopted the negotiating mandate only in July 2019, and by that time, it had also declared its climate neutrality objectives in the EU Green Deal. Formal negotiations then started in 2020. Most importantly, the EU mandate and the Energy Charter Conference decision on the modernization of the ECT were partially overlapping. Of course, there were common topics that were identified and the need to reform them, but there were also differences. For example, the EU mandate included a list of EU-centered proposals for the modernization of the ECT, for example, provisions on state aid provisions, the disconnection clause, the multilateral investment court proposal, etc. Moreover, within the EU bloc itself, the EU Commission and the EU member states do not share the same views on the outcome of this process. The European Commission defends the reform of the treaty, believing that, and I'm quoting from the statement of the Commission, that the results of the modernization process respect the energy transition and climate objectives, as well as modern investment protection rules, which is particularly important in the current context where a wave of investment in green energy is expected. On the other hand, member states considered that this process will never be considered compatible with EU climate objectives. For this reason, as I mentioned, Spain has declared that it will not support the modernized version in the Council vote. Belgium said that it would not abstain, that it would abstain from voting. And Germany has also considered abstaining from the EU vote on the updated text. Now, keeping these issues in mind, I will now address the prospect of withdrawal from the ECT of the EU member states and the effects from a public international law perspective. And I'll focus on 4 scenarios. In the first scenario, member states' dissatisfaction with the modernized agreement renders really remote the possibility of implied termination of the current version of the ECT by concluding a later modernized treaty in accordance with Article 59 of the Vienna Convention. For some commentators, the modernized version would be better than keeping in place the current ECT, considering the novelties introduced by the modernized version. Amongst many others, it contains new articles on the right to regulate, on the resolution of disputes on sustainable development between contracting states, a new article on subsidies, a disconnection clause, new articles on frivolous claims, climate change and clean energy transition. Although member states are not persuaded by these changes. Under the second scenario, it's also unrealistic to think that should the amendment to the ECT fail, all its contracting parties would agree to terminate the current ECT by mutual consent in accordance with Article 54 of the Vienna Convention. Termination of the ECT has never been on the agenda of the Energy Charter Conference. And such termination would not affect the sunset clauses of the ECT, a topic to which I will return shortly. So the remaining options for states that reject the modernized version, but refuse to continue to be bound by the existing ECT, is to withdraw from the treaty either unilaterally or collectively through a coordinated approach. The former is the route that the EU member states have followed so far, although there is a call for an EU and member state coordinator to withdraw from the ECT. Now, going into more specific issues concerning the unilateral withdrawal, it's important to understand the legal framework that governs the unilateral withdrawal from the ECT and the effect that this may have. In the third scenario, which unilateral withdrawal from the ECT is governed by Article 47 in the Energy Charter Treaty, and it's also supported by Article 54 of the Vienna Convention. According to these provisions, a party may withdraw from the ECT 1 year after the deposit of the request. Unilateral withdrawal, however, does not affect the survival clause of the treaty. In any case, in the case of the ECT, paragraph 3 of the Article 47 guarantees substantive and jurisdictional protection to foreign investment for an additional period of 20 years. The validity of the survival clause in the case of unilateral withdrawal, and also consequentially consent to arbitration, is an uncontested principle in international investment arbitration practice. Arbitral tribunals recognize that states retain the sovereign prerogative to amend their laws, but, and I'm quoting from a decision of the tribunal in Green Tech Energy, if the state gives an investor express assurances that no amendment would occur, the investor must be fairly compensated if those assurances are violated. The only example that we can look at of a state withdrawing from the ECT is Italy, with withdrawal that took effect in 2016. So I was looking at the cases that are on the ECT database to see what happened after the withdrawal took really effect. And there were 6 disputes filed under the ECT after January 2016. One of those cases was about oil and gas. The others were about renewable energy. And this is after withdrawal. But what is interesting is that if you look at the role that Article 47.3 played in this withdrawal process, so the survival clause, we will note that in those fewer words that have already been concluded, the discussion about Article 47.3 is minimal. In 2 decisions, tribunals simply mention them in a footnote. In the case Silver Ridge, for example, with an award of February 2021, the tribunal simply says that the survival clause is perfectly valid, and so Italy continues and remains obliged to bound by the ECT. Again, only in a footnote, the tribunal mentions Article 47.3 in another case, the Sun Reserve case against Italy. This was an SEC case. So tribunals have confirmed that filing a case after the date of effective withdrawal also will not neutralize the sunset clause in the ECT. So not just when you have filed the case before the withdrawal has become effective, but also after. And I'm referring to the decision of the arbitral tribunal in Esposol, another case under the ECT against Italy. So states withdrawing unilaterally would not be saved from the application of Article 47.3 of the Energy Charter Treaty. Now we move on to the last scenario, which is the proposed coordinated withdrawal. And the way that the EU member sees is a termination of the survival clause in tandem with the withdrawal from the treaty. Now, EU member states have already adopted this approach when terminating their intra-EU VITs in 2020, and the effect, but that is an agreement which only applies to 23 member states of the European Union. There are some countries which did not participate in that agreement. So for those countries, this agreement has no effect, which makes me think also that should only 6 member states of the European Union withdraw currently from the ECT, we also need to take in consideration that the rest of the member states will continue to be we obliged to respect the ECT commitments. Now, of this, when again looking at this past experience of having or adopting a termination agreement, which also tries to neutralize the survival clause in the context of the intra-EU VIT, again, it's clear that the fact that the agreement became effective does not mean that you can stop ISDS clauses. There were around 6 cases filed after the agreement on intra-EU VITs what became effective, and they concern Romania, Slovenia, Croatia, the Czech Republic, and Denmark as a respondent in intra-EU VIT cases. Now, these cases are cases that were filed after 2020, and so we don't have yet any award from the arbitral tribunals, and we are not sure what will be the interpretation of the arbitral tribunals on the effectiveness of Article 47.3, of the survival clauses of these intra-EU VITs. So they are pending cases, but there are some public international law perspectives which pose some challenges to this issue. I'm referring to the example of another case, which is the Baghdad versus Egypt case, a decision on jurisdiction adopted in 2017. Now, this was not an ECT case, but was a case about a BIT between 2 contracting parties and another BIT from the same contracting parties substituting the older BIT. Now, when the claimant brought the case in arbitration, it stated that the old survival clause in the old BIT would survive, actually, it could be applied to the new BIT that was adopted by the parties. And the tribunal accepted this argument, the survival clause of the old BIT could still be relied on. The other challenges that relate to public international law are those concerning the application of Article 41 of the Vienna Convention. There is a strong theory of third-party rights in investment arbitration, which we mentioned a little bit during the second panel. There is a concern for the object and the purpose of the treaty, so any act of the contracting parties which may affect the object, the real object and purpose of the treaty under public international law can have a role to play. And there may be a risk of considering the neutralization of the sunset clauses as a form of violating customary international law. One argument can be raised about this. And one can also, for example, rely on Article 62 of the Vienna Convention, which is about fundamental change of circumstances as a ground to justify the adoption of an agreement of this kind, which neutralizes the survival clauses. However, it was interesting because, as we were discussing this morning, there was a statement published on the Energy Charter Secretariat website saying that Article 62 would not be considered as applicable in case states try to withdraw from the ECT. Now, considering all these elements, I think that the current modernization process represents a missed opportunity with respect to the following issues. First of all, the modernization process did not address Article 47.3 of the treaty and did not limit the application of the survival clause. It could have been brought in line with the general EU approach in the recent VITs, and bringing the time limit of survival grows from 20 years to 3 or to 5 years, for example, which would have been a more accepted solution. It had also failed to reform the ISDS provision to include reference to the multilateral court system in line with the EU approach in other international agreements. And it has missed the opportunity to introduce a conflict clause in the ECT, either to modify the existing Article 16 of the ECT or to introduce a new article. And this is the non-derogation clause, which normally clarifies the relationship between different international agreements. In this way, it would have also clarified the relationship between the Paris Agreement and the modernized version of the ECT. So going forward, and these are my final observations, the Energy Conference should consider taking the following actions: reopening the negotiation of the modernization process. 2 years were not enough, apparently, to deal with all the relevant issues in a satisfactory way. To identify the provision in need of revision, to introduce more public consultation and transparency during the process, the negotiation process. If we compare this process to the ISDS reform process, we'll see that debates at the ISDS reform level are completely different from the debates that surround, the modernization of the ECT. Even the text of the modernized agreement became public only in September this year, and there was no way even for academics to comment or to submit their views on those drafts. And the final point is to finalize the process, the accession process of the candidate members, and include them in the next round of the modernization. This would guarantee that the Global South perspective is equally represented in the process and can shape the future of the Energy Charter Treaty. I'll stop here because I'm sure that we'll discuss these issues further in the question Q&A session. Thank you.
Thanks so much, Blerina, and fits very well. Vid continues to speak about international customary law.
And investment law regime in general, actually. It's easiest. So I'd first like to thank Christina for inviting me to this panel and for giving me actually a free hand. She said, please address something related to the public international law aspects of ECT modernization, modification, or withdrawal. And bearing in mind the scope of the presentations of my co-panelists, I decided to attempt to evaluate the option of withdrawal from the perspective of the broader investment law regime. What legal consequences will the termination of the ECT have on the energy transition? Will exit from the ECT prevent actually the investors using the investment law regime to challenge measures phasing out fossil fuels? The ECT belongs to the still relatively few multilateral investment treaties. As we know, the regime governing the protection of foreign investment continues to be governed, set out in a patchwork of primarily bilateral investment treaties. And although the EU member states terminated the intra-EU BATs following the ACMEA decision, a great number of extra-EU treaties remain in force or are yet to come in force, such as in the case of the CETA. What implications does the continued existence of these treaties have for the energy transition? And in the following few minutes, I shall look at two specific issues. The possibility, first of all, of existing investments in the energy sector coming under the protection of extra-EU treaties as a result of corporate restructuring. And secondly, the role of customary international law and what role that's, whether or not customary international law continues to play a role in the protection of foreign investments. Now, the first aspect was actually prompted by a news on a website that I recently came across. Namely, following the Comstra decision of last year, law firms responded with the following advice to their clients: consider restructuring. In the first part of my presentation, I'll therefore deal with the question whether restructuring of one's investment operations with a view to gaining protection under investment treaties is actually permitted under international law. Short answer, it depends. When it comes to creating new investments, the stance of investment tribunals has been rather clear. As the tribunal said in Aguas del Tunari, it is not uncommon practice and absent a particular limitation, not illegal to locate one's operations in a jurisdiction perceived to provide a beneficial regulatory environment, including in terms of the availability of a bilateral investment treaty. Now, the practice of nationality planning, as the term is used by practitioners, by law firms, is indeed a well-established and broadly tolerated one in investment arbitration. What is not tolerated, though, is corporate restructuring of existing investments with a view to gaining access to investor-state arbitration, where such restructuring occurs by tortious means. And this is currently deemed to occur where restructuring happens after the beginning of dispute, specifically with a view to obtaining the protection of the treaty. As attested to by among other cases, the Philip Morris Australia case, when an investor will change its corporate structure to gain the protection of the treaty, at a point in time where a dispute with the host state will be foreseeable, the commencement of investment arbitration will be deemed to constitute an abuse of rights, and an investment tribunals will very likely decline jurisdiction. And to that end, yes, a dispute will be considered foreseeable when there is a reasonable prospect that a matter which may give rise to a treaty claim will materialize. The dispute need not to be foreseeable, though, by those directly responsible for carrying out the restructuring. Now, having said this, allegations of abuse of process have not been taken lightly by investment tribunals. The standard of proof required is that of persuasive evidence, and the prospect of corporate restructuring being found impermissible will very much depend upon the fact of the case. Now, the main factor actually permitting corporate restructuring to bring investments under the scope of investment treaties is that many existing treaties, particularly the old-style BATs, and particularly those by the Netherlands, among others, treat as an investor any entity established or incorporated in one of the contracting parties. On the website, I provide the example of the treaty definition of investors in the Netherlands, Hong Kong BAT. Not that I would suggest it will be used for corporate restructuring, though I selected this case simply because Philip Morris Australia or Philip Morris Asia did rely on a Hong Kong Australia BAT to try to gain protection vis-a-vis, well, to challenge the measures adopted by Australia. And it shows that it's not unlikely for investors from capitalized quality states to resort to a jurisdiction such as Hong Kong. Now, the recent inclusions into investment treaties of the requirement that the investors have a business presence in the States are expected to provide an important limitation of nationality planning practices. One such requirement can be found in Article 8.1 CETA, which requires that enterprises claiming investor status to be constituted and have substantial business activities in the territory of the Republic. Similar language is found in EU Singapore IPA, EU Vietnam IPA, and EU member states now increasingly seek to introduce similar language in their renegotiated bilateral investment treaties. What the requirement of substantial business activities essentially does is that it constrains corporate restructuring through simple mailbox companies. However, it does not prevent restructuring through a subsidiary that has already substantial business activities in the territory, at least in the absence of other limitations, to which I return in a moment. Now, what must be borne in mind, of course, is that this requirement of substantial business activities is still relatively absent from the larger part of BATs. And in the absence of such requirements in a treaty definitional provision, the treaties have been deemed to apply to mere holding or shell companies with no other business activity than the holding of the shares of the subsidiary. Now, does this mean that a timely executed restructuring through a jurisdiction covered by the least limitative treaty can therefore offset the termination of the ECT? I submit that not necessarily. Why? There is an interesting trend observable in arbitral practice to exclude from treaty protection investment structures resulting from nominal restructuring, that is, investment structures with restructuring with little or no transfer of actual funds or assets. Over the past 10 years, we've seen tribunals declining jurisdiction where investments had been acquired by the claimant at no cost, where the contribution was purely nominal, such as through the payment of what was okay, $6,500 for a share that was allegedly worth $1 billion, or where no contribution otherwise was made to the purported investment, whether by way of money, concession rights, technology, know-how, expertise. Now, in terms of arbitral method, treaty protection was not denied in these cases on account of abuse of rights. The tribunals actually grounded their decisions in the text of applicable BATs, which contained requirements such as the investments be made, or investments be invested by investors, or simply be investments of investors. And so tribunals interpreted these requirements, literally sometimes the mere formulation of as implying some sort of action of investing, which therefore required that the value, some element of value takes place and transfer of value takes place across borders, although it's currently not yet settled, but that has to happen cross-border into the wholesale, or that transfer of value can actually take place somewhere else, so outside between two holding companies in the third jurisdiction. Now, what is clear is that this requirement could play a role under CETA, which defines an investor as a person or enterprise that seeks to make, is making, or has made an investment. So you see that this provision could provide limitation for simple restructuring practices, even through subsidiaries that have an established business practice. In sum, there are signs of investment tribunals becoming increasingly wary of investment restructuring that is not genuine, but as you know, for any investment case where tribunals are willing to closely scrutinize investment structures, there is at least one another case where tribunals do not even bother looking behind the corporate veil. Now, this brings me to the second point, to which I would like to turn, and this is that the absence of treaty-based protection of investing will not also result in the disappearance of obligations pertaining to the treatment of foreign investors. Under customary international law, states remain bound to provide what is called the minimum standard of treatment to foreign investors and other aliens on their territory. Before the advent of investment treaties such as the ECT, it was primarily these rules of customary international law that were used as a basis for international claims arising out of injuries to foreign investors, and true capital importing states of the Global South heavily contested the validity of these customary rules in the pursuit of the new international economic order. And true, it was in response to these contestations that capital exporting states actually started to conclude BITs, purportedly codifying different aspects of the minimum standard. However, despite these contestations, today, it is the rules of minimum standards of treatment are considered to not have been superseded with the advent of investment treaties. On the contrary, they continue to apply alongside treaty standards and have, in fact, continued to evolve even in context of treaty-based arbitrations, namely in the context of NAFTA and US and Canadian BATs and FTAs, where the standard of fair and equitable treatment and full protection security are actually tied to and applied as part of the minimum standard of treatment demanded by customary international law. Of some concern, of course, is that this minimum standard of treatment is taken to impose slightly less onerous obligations than those under an unqualified equity standard found in the old-style European BATs and the ECT. In order to be considered violative of the minimum standard of treatment, conduct needs to be egregious, it needs to be arbitrary, grossly unfair, unjust, idiosyncratic, etc., etc. And it is also true that in more recent cases, tribunals have slightly departed from the suggestion that the minimum standard, the one that is formulated here, would have been the same one as those formulated in the near case in the 1920s. The threshold remains, or it seems to be very high, with tribunals continuing to insist upon outrageous conduct as the relevant touchstone. Now, perhaps most importantly here is that the concept of legitimate expectations, as we know it in the regular context of equity claims under the ECT and other regular, well, the European type investment treaties, has a more limited role to play in the application of the minimum standard of treatment. Namely, both the US and Canada have continued to assert that there is actually no general obligation under customary international law to protect an investor's legitimate expectations. The matter is not entirely settled in arbitral practice, but what is clear is that the protection of legitimate expectations under the minimum standard is not considered an autonomous element. So in the sense that the frustration of legitimate expectations in itself would be sufficient to generate liability. It has to somehow be coupled with other egregious conduct. And in this way, I would say that the scope of protections under customary international law comes closer to the FET standard as now formulated in the amended Energy Charter Treaty, or at least what they're claiming that the amended ECT standard will be. Further, just as the ECT, customary international law equally does not permit expropriations, whether direct or indirect ones, unless the expropriations are taken, well, the investments are taken for a public purpose in a non-discriminatory way, in accordance with due process law and against payment of compensation. However, the customary law prohibition of uncompensated expropriations must be applied in light of the general doctrine of police powers. The doctrine, which is itself recognized as constituting part of customary international law, implies that states reasonable bona fide exercise of police powers in such matters as the maintenance of public order, health, morality, but also protection of the environment. It's recently confirmed in Ingo versus Colombia case, excludes compensation even when it causes economic damage to the investor. Now, the doctrine will seemingly find explicit recognition in the amended ECT text, which in this sense does not create a derogation from earlier obligations, but seems to merely codify customary international law. Of course, the perhaps of greatest concern us in the context of customary international law is that in the absence of an applicable investment treaty, customary international law standards cannot be enforced by means of investor-state arbitration. But does that mean that they cannot be enforced otherwise, such as by means of interstate proceedings in the exercise of diplomatic protection? Well, it may seem unlikely in the EU context for member states to take up claims on behalf of their nationals with respect to dispute interstate. But I would say that interstate proceedings between EU states before the ICJ or in another interstate forum are not unprecedented. We know, we can still recall the MOX plant litigation. There is currently dispute between Germany and Italy before the ICJ concerning immunities, of course, and not investment, but it would not be entirely unprecedented that submission to international adjudication, that there would be an investment-related dispute submitted to ICJ, and that being a dispute between capital exporting states. Clear example is the ACELG case, which was brought before the ICJ in the 1980s by the United States in respect of a dispute between the two US corporations and Italy, arising out of Italy's requisition of a plant. In conclusion, transition to a post-carbon society may seem easier without the ECT, but one cannot preclude that other obligations on international law, a conventional customary, could not be used to challenge measures phasing out fossil fuels. Leaving aside the option of interstate proceedings, if you want to eliminate potential investor-initiated claims against the phase out of fossil fuels, you need probably to terminate or at least amend all the other VATs as well. This applies also in the event the amended ECT enters into force, in as much as the amended ECT would foresee then in the possibility of carve-out for investments in fossil fuels, which then would not preclude the effective investors in those cases to resort to non-ECT investment treaties. This then brings me up to the point raised already by Professor Akuri in the morning, to the argument that we may need to exit the investment treaty regime as a whole. It's not, I do not identify an answer to that. I would rather pose back a question, and that is, what is actually, or is there actually a role for international law in stabilizing expectations? Do we need an international law framework at all as a way to support investments facilitating the transition to a carbon-free future, or can we indeed simply do away with all investment treaties? Thank you for your attention.
Thank you so much, Vid. And on to Kyla on the screen. Yes, works perfect.
Great. All right. Good afternoon, everyone. Thank you so much for the invitation to join virtually today. I just want to apologize in advance if my 4-year-old interrupts me at some point. She should be at school today, but unfortunately, the provincial government here doesn't actually believe in paying educational support staff a living wage. So there's a strike for the indefinite future. So my kids are home unexpectedly. So I am sad to have missed the other presentations. I hope to catch up with them in the recording, and I'm the last one of the day. So it's going to be a challenge to add something new, but I'm not a lawyer, so I hopefully bring a bit of a different perspective, focusing on more of a climate policy angle for this. So this presentation is based on work that I've published with co-authors from Boston University. It's generally on investment treaty protection of fossil fuel assets. Is published, the first part of it was published in Science in May, and a companion piece is coming out in the journal Climate Policy, hopefully sometime in the next couple of weeks. Like it to come out before the Energy Charter Conference, but academic publishing is rather difficult and slow. So I'm going to briefly explain the research and then turn to that question of whether the measures within the modernized ECT address the concerns that we have raised in our research. So our research built on the International Energy Agency's Net Zero by 2050 report, which came out last year. This report identified a very specific set of upstream oil and gas projects that are considered to be incompatible or inconsistent with trying to keep the world to 1.5 degrees of warming. And this is any projects that don't have a final investment decision by the end of 2021. More recent science actually suggests that that we need to do more than that. We also have to retire early some existing projects. So in addition to looking at projects that didn't have a final investment decision at the beginning of this year, we also looked at projects that are under development but not currently producing. And so using a database of energy projects called Rystad UCube, we identified those that were clearly protected by investment treaties. You can get into the methodology in the Q&A. It is somewhat problematic because we relied on the headquarters for the company to determine nationality. And then we used various calculations of what's called net present value in order to try to speculate on a range of financial liabilities that states could face if they followed this pathway and canceled all of the projects that were incompatible with 1.5, but had already received some kind of government approval, like an exploration permit, for example. And the upper end of our estimate was $340 billion. This is, again, all investment treaties, not just the ECT. I don't actually think that number is the most important thing that came out of the research. I thought it was more interesting that the distribution of the risks is significant, because a lot of it is in lower middle income countries that many of them are extremely vulnerable to climate change. So we did also find that there are quite a lot of treaties that are protecting these assets. I think it was 334, but some of those treaties stood out as being especially problematic, which brings us to the ECT, which we found was protecting more of these 1.5 incompatible upstream oil and gas investment than any other single treaty. Probably not that surprising given how much coverage it has. We reported an upper estimate of $20 billion of assets that are solely protected by the ECT. So I'm stressing there that these are projects that are not covered by other treaties. If we looked at projects that are covered by multiple treaties, because there are investors from multiple countries involved in the project, or because there are other treaties that are overlapping with the ECT, then the value protected by the ECT almost doubles. And also, this is an underestimate probably because of the limitations of the data that we had access to. So we also looked at what would happen if the ECT was expanded to all the countries that have started the accession process. And we found that expansion would increase the mean NPV, so the mean of all these different oil and gas prices that we use to try to make estimates. It would increase it by about 38 billion across 26 countries. The most consequential additions would be Iraq, which would add $17 billion of risk, Mauritania, 8 billion. And then several other countries like Tanzania, Kazakhstan, Niger, Jordan, and Senegal would have between $1 to $3 billion worth of risk. And that's in the forthcoming climate policy paper. So that's just all to say that Energy Charter Treaty is very bad in theory. Obviously, no one is currently following the International Energy Agency pathway. We don't have countries doing what is needed to be done for the large part, but theoretically, if countries actually stepped up and started to phase out production, then there could be a lot of potential ISDS cases. And then you've already heard about today how the ECT is also bad in practice. So the Rockhopper case, I'm sure as you've discussed, it was not necessarily a climate case because it was a lot about opposition concern about the local environment, but it is a very good example of what we need to happen, which is bans on production, and the outcome potentially will have a chilling effect on other countries that want to take similar action. And we do have some preliminary evidence that investment treaties, including the ECT, may have a chilling effect. So there's a case of France where there was a threat of ISDS from a company called Vermilion, and subsequently the oil and gas phase out law was redrafted to allow existing permit holders to renew their permits. Denmark, one of the two initiators of the Beyond Oil and Gas Alliance, or BOGA, which is an important initiative at the international level to get countries to actually follow through with production phase out. They reportedly set the deadline for their oil and gas phase out at 2050 in order to try to avoid ECT claims. I'm not saying that ISDS is the only factor in any of these decisions, but it's clear that it has played a role. And then as far as smoking guns go, Elizabeth Meager got a pretty good quote from the climate minister of New Zealand on record saying that the country didn't join that Beyond Oil and Gas Alliance as a full member because the government was concerned that a Paris-aligned phase out of oil and gas would have sparked ISDS claims. Obviously, that's not the ECT, but I think we can agree that these kind of issues are relevant across an investor treaty case, investment treaties. So additionally, the ECT and other treaties are going to make the energy transition more expensive for the public, either through award payouts or because companies use the specter of arbitration in their negotiations with government for compensation. So in the case of the Dutch coal power phase out, the government developed a mechanism to calculate compensation for impacted investors. And one company did take that compensation, but then the other companies felt that was what was offered was insufficient and that they preferred to instead launch claims in arbitration. An independent analysis by IEFA and Ember suggests that the plants were already loss-making before that phase out was announced, which indicates that ISDS would be a windfall for these investors. And then with the German coal power phase out, that involved negotiated compensation scheme, and it's been widely criticized as being overly generous. And I understand that it might be being investigated by the European Commission. There have been observers that have pointed out that the contracts negotiated with the main firms involved explicit provisions to prevent ISDS cases under the ECT. So given all of these issues, what does the modernization do to address them? I'm ignoring all the tinkering with the wording clauses on fair and equitable treatment and so forth, because I think all of those kinds of reforms are window dressing. I think that the key aspects are the intra-EU carve-out, the August 2023 end for protection of new fossil fuel investments in the EU and the UK, and a 10-year phase-out for existing investments in those regions. I think the intra-EU aspect is pretty good. That will kill a lot of potential ISDS cases, unless we see corporate restructuring, which was already discussed. On the ending of protection for new investments, that is also good, but it should have been at least backdated to the beginning of this year in line with the IEA. August 2023 is too late, especially as the UK government seems poised to approve some major projects in the North Sea before then. Also, new investments outside the EU and UK are still protected, so the ECT as a whole is still 1.5 incompatible. As for the 10-year phase out, this is really insufficient This is a critical decade for climate action, and we will need to retire some existing developments early. We don't actually even know, as far as I understand it, when the 10-year period will start, because it depends on when the modernized ECT is ratified. And we could have protections lasting for fossil fuel projects up until 2040, which is far, far too late. And I think it's worth recalling that when the NAFTA was modernized, absolutely all investment protection between Canada and the US was phased out in only 3 years. So as of next July, there will be no fossil fuel investments in Canada or the US that will be protected by the USMCA. 3 years is obviously still too long, given that it's given TC Energy the opportunity to sue the US over the cancellation of the Keystone XL pipeline, but 3 years is still better than 10 plus. And again, the phase out only applies to part of the membership of the ECT. So in terms of what the alternative is, I know that there's already been discussion about this today. I've also seen a lot of back and forth on in terms of blogs and posts on a listserv I'm on that questions whether it is possible to have a coordinated withdrawal that neutralizes the sunset clause. I'm not a lawyer, so I can't really come with a definitive answer to that. But what I can say is that when we looked at our data on 1.5 incompatible projects, we found that there was only a very small amount of investment in the UK that was hailing from outside the EU. So there was a very small amount of investment from Japan and from Azerbaijan. And so a collective withdrawal that did between the EU and the UK that neutralized the sunset clause would eliminate 99% of the ISDS risk for the UK on this specific set of upstream oil and gas projects. And then in terms of the EU, all of the ECT covered investors in our data set are either European or British, and therefore a collective withdrawal would eliminate 100% of possible claims. And then in terms of the projects under development, it's 92% of the risk for the UK, and again, 100% of the risk for the EU would be eliminated by a coordinated withdrawal. So that obviously, the issue of restructuring still comes in there, but it does show, I think, importantly, that a lot of the risk could be neutralized potentially if a coordinated withdrawal is legally possible. And I would just like to add that in terms of the question of restructuring, but also just generally in terms of the investment treaty system, I absolutely see ECT withdrawal as a first step in a larger project to dismantle the entire investment treaty regime. So the research that I've done definitely demonstrates that the ECT covers more 1.5 degree incompatible oil and gas assets than any other treaty. But it is notable that the protection it provides predominantly applies to wealthy European countries. So for example, if the ECT was terminated, the mean net present value of all the treaty protected oil and gas projects would decrease by 11 billion across 19 countries, but only 6 of those countries are lower middle income. So Azerbaijan, Kazakhstan, Romania, Tajikistan, Ukraine, and Yemen. And their total reduction of potential ISDS wards is just 10% of the total reduction expected for the 13 high income countries. The country that would benefit the most from ECT termination is the UK. They would, on average, avoid liability of 5.3 billion, which is nearly half of the total average reduction for all ECT protected countries. I care very much, obviously, about the ability of developed countries to enact climate policy and have policy space to do what's needed to be done. But we do, in the countries that we are based in, like Canada and the EU, have far more resources available to battle these cases. And the investors involved are also largely based in our countries. The true injustice, as far as I see it in the ISDS system, is that it's going to reverse any flows of climate finance. So we should have finance going from north to south, and instead we're going to have claims against countries in the global south, and that money flowing back to the north into investors that are based here. And just to finish off, in case anyone is curious, I'm not sure if this has been discussed or not today, I don't think that fossil fuels companies should get a single cent of compensation, because they have created the situation that we are now in by fostering denial and delay at every possible opportunity. And any expectations that they have to business as usual is basically any expectations that they have to business as usual is based on obstructionism and is therefore, in my opinion, entirely illegitimate. You may think that, well, you're an environmentalist, that's just the opinion you have there. But I would note that even the editorial board of the Financial Times has taken the position that if profits are to be private, so too should losses, because this is both the heart of the capitalist social contract and fundamental to the ability of markets to deal adequately with the challenge of climate change. Thanks very much for your attention.
Great, wonderful. So yeah, very powerful set of contributions.